The United States Supreme Court has agreed to hear two blockbuster Second Amendment cases, Viramontes versus Cook County and Grant versus Higgins. Now, both cases challenge state and local bans on commonly owned semi-automatic rifles, including AR-15 style firearms. So if you've been waiting for the Supreme Court to finally answer whether politicians can outlaw an entire class of firearms owned by millions of law-abiding Americans, well, your wait is almost over. This isn't the final decision, but when we talk about firearms being in common use, the AR-15 fits that description perfectly. There are over 32 million of these firearms in the hands of American citizens. Now, the court has agreed to hear the cases. The arguments are still ahead, and no one knows how the justices will ultimately rule. But make no mistake, this is huge. This is a big moment because for decades, many Second Amendment supporters have been playing defense. Every legislative session, another restriction. Every election cycle, another promise to ban something. Every tragedy is used by the political left to limit what law-abiding Americans can own. And the political left has treated the Second Amendment as though it were somehow less deserving of protection than any other constitutional right. But think about it. Nobody says the First Amendment only protects speech the government approves of. Nobody says the Fourth Amendment only applies when it's politically convenient. But when it comes to the Second Amendment, well, for years we've heard, well, this gun is okay, but not that one. This magazine is acceptable, but not that one. You can exercise your constitutional right here, but not there. And only after politicians decide exactly what they think you should own. Well, that's backwards. The Constitution doesn't exist to protect the feelings of those who've been brainwashed to fear guns. It exists to protect rights even when they're unpopular or if some snowflake is scared. That's the entire point of the Bill of Rights. Now, let's talk about these cases. Illinois and Connecticut have laws banning many semi-automatic rifles that gun grabbers call assault weapons. Now, supporters of these laws argue that they're needed to improve public safety. Well, these are actually among the most commonly owned rifles in America, used overwhelmingly for lawful purposes such as home defense, recreational shooting, hunting, competitive shooting. And under the Supreme Court's decision in Heller and Bruin, firearms that are in common lawful use are protected by the Second Amendment. That's the constitutional question now headed to the highest court in the land. Not whether someone likes these rifles or whether politicians approve of them or whether some crybaby liberal has been triggered by them, but whether the Constitution protects them. That's the question. And here's what has a lot of people paying attention. Since Heller recognized an individual right to keep and bear arms, and Bruin instructed courts to evaluate gun laws based on the nation's historical tradition of firearm regulation, lower courts have reached different conclusions about semi-automatic rifle bans. The Supreme Court now has an opportunity to provide one answer for the entire country. If the court ultimately agrees with the challengers, the impact could extend well beyond Illinois and Connecticut. Now, similar bans in other states could face renewed constitutional scrutiny. Look out, New York, we're coming for you and your so-called New York SAFE Act. That's why this one is of the most consequential Second Amendment cases in years. This may be a chance to stop decades of incremental erosion of gun rights through unconstitutional legislation. Now, politicians have too often focused restrictions on citizens who obey the law rather than on criminals who ignore it. There's no denying the importance of the constitutional question before the court. Constitutional rights shouldn't depend on your zip code. A right in Arizona shouldn't become a felony in New York. A right in Texas shouldn't disappear in California. The Constitution was written for all Americans, not just the ones elected officials happen to agree with. So today is not the end of the fight. It's the beginning of what could become one of the most important constitutional cases of this generation. Now the lawyers will argue. The justices will deliberate and the country will watch. And sometime next year, the Supreme Court will tell us whether shall not be infringed means what our founding fathers intended. For millions of law-abiding Americans, that answer has been a long time coming. This case won't just shape gun law. It'll help define the scope of one of the fundamental liberties protected by the Constitution for years to come. Stay tuned, America. The next chapter in the fight over the Second Amendment is about to be written. So we're going to talk about this and many other things with His outspoken political views make him a real delight at family gatherings. Anthony Diso. So, I always laugh. I always think that's funny. Anthony's always got some sort of. So anyway, so the two big cases coming to Supreme Court. The firearms community, Second Amendment community, feels pretty confident that they're going to finally put a stop to all these so-called assault weapon bans. What are your thoughts?
Yeah, that'd be nice. It shouldn't be that hard to do, you know?
It shouldn't be.
Well, it should just, isn't that their job? Follow the Constitution?
Yeah, but what did these knuckleheads in the Supreme Court do? Some of them went and they granted birthright citizenship recently. So I don't know. My fear is that they just can't be trusted. Can you believe they just... That's another topic. We can talk about that later, but... Yeah, so they granted birthright citizenship in a majority vote for it. And so that's why, you know, although it makes perfect sense, it seems to be undeniable, a semi-automatic rifle, regardless of how many attachments it has, and it's a commonly used, commonly owned, it should be protected by the Second Amendment. But I hope by the time they deliberate this that they're not drinking the left-wing Kool-Aid. What do you think?
Yeah, that's the problem. I mean, it's I don't know. It should be easy as 1, 2, 3. Okay, fits the Constitution, Second Amendment. Good, we're good to go. Nope. You always gotta. You can't. I don't know. It's hard to trust them. It's 50-50 with them.
Well, I mean, tell me any gun law that's not an infringement.
Shouldn't have any gun laws.
There should be nothing. They should be focused on the criminals, but they don't. Anything you talk, you know, and the gun grabbers, the liberals will say, well, we need background check. Well, where in the Second Amendment does it say the right of the people to keep and bear arms shall not be infringed? As long as you get a government background check.
Well, they want to write. They want to scribble. Well, sorry, they can't. Nobody today knows how to write cursive, so they're not going to be able to get that in there.
They can't even read the Constitution.
They can't even read it. I don't know. What's that say?
Anything though. Think about, and then you got red flag laws which violate the Fourth Amendment, and then you got fees. You got some states wanting to make you carry insurance. You got waiting periods. You got fingerprint. You got gun registries. You got magazine capacity limitations. Are you kidding me? Back in the days of our founding, you know, because Bruin brought us the historical tradition precedent now. Now, all gun laws must meet the historical tradition. What are the gun laws that these people are proposing now, current times, do they meet historical tradition? In other words, was there similar laws back then? And I don't know of any, really. I mean, I could probably maybe find something similar, but the magazine capacity restriction is really hysterical. I don't think back in 1791, when the first 10 amendments were ratified, that there was a law that said, well, you've got the right to keep and bear arms, but you can only carry 10 bullets.
I don't think they said that.
I don't think so.
I think they had a giant bag full of bullets, and they just kept loading.
I think most of the time they didn't have more than 10 bullets because they were just hard to find, and they were hard. Yeah. They had to melt them down.
But they didn't say, you can only have 10, buddy. That's it. 11, you're gone.
Yep, 11, you're in trouble.
That's
Throw them in jail.
In prison. That's it. He's out.
So ridiculous.
It's ridiculous.
So, but this is a good opportunity
for the justices to do the right thing.
Yeah, let's hope they do the right thing. And now we know we can't trust Sotomayor and Jackson and
they're Looney Tunes.
But we can hope that we know Clarence Thomas will do right, Alito. But we have some questionable Supreme Court justices. And, I don't want to bring everybody down, but I just want to be practical about this. I have a good feeling that we're going to win these cases and that the so-called assault weapons are covered under the Constitution. Semi-automatic, commonly owned semi-automatic rifles are are protected. But, I mean, it's like we're going to be on eggshells for the next year until they figure this thing out. I don't trust them. I don't fully 100% trust them.
I don't.
It should be a slam dunk, though.
Should be.
It should be.
Yeah, we're good.
Yeah.
No, it'll be like,
Yeah.
I don't like it.
Yeah. They scare me.
They scare me. They probably got 10 in their house.
The right to keep and bear arms shall not be infringed,
But
unless they scare you.
Yeah, scary little guy on a table.
Unless the gun
He's
scares
just gonna
you.
run out of the house and just start going kaboom boom. That's what these idiots think.
The right to keep and bear arms shall not be infringed, unless Moms Demand Action doesn't feel that it should.
Yeah, a whole another set of losers right there.
Oh God, they are so bad.
What a bunch of
Anyway,
idiots.
they are. I agree. Let me get to one of our sponsors who are not idiots. These are actually the ones who are protecting your rights. You want to know who's fighting for your gun rights? Gun Owners of America. Now, GOA is the no compromise gun rights group, so I urge you to become a member at gunowners.org. What have they done? Well, GOA secured preliminary injunctions against the ATF pistol brace rule. GOA members submitted a record 85,000 plus comments opposing the ATF's universal registration check rule. They helped enact permitless carry in Nebraska and Florida. GOA secured victories in California, Illinois, New Mexico, New York, Oregon, Pennsylvania, Virginia. Plus, they won 2 legal victories against the ATF's zero tolerance policy. And GOA fought to overturn Joe Biden's ban on funding hunter education, shooting sports, and archery in schools. So with the constant attacks on our Second Amendment, we often ask ourselves, what can I do about it? Well, this is what you can do. You can become a member at gunowners.org and help us save the Second Amendment.